When we are born, a CESTUIK trust is set up using our birth certificate. A non-living entity is created using dog Latin, capital letters. Whenever capital letters are used, it capitalizes on the name. We are given a birth certificate and is then registered with the government that is a private company that is owned by the Vatican. We are registered to the Crown as cargo as a lost at sea, which is the Holy See of the Vatican. CESTUIK via ACT 1666, a CESTUIK trust. A CESTUIK trust is a person for whose benefit a trust is created, a beneficiary. Although legal title of the trust is vested in the trustee, the CESTUIK trust is the beneficiary who is entitled to all benefits from a trust. A CESTUIK use is an archaic term of property law that describes one who has a beneficial interest in land held by someone else. Title and possession as well as the duty to defend the land is held by another, but the CESTUIK use has the right to rents, profits, and other benefits from the land. A CESTUIK vi is the person whose life is used to measure various things, such as the duration of a trust, a gift, or an insurance contract. It can also be used to mean the person upon whose life a policy of life insurance is drawn. A CESTUIK vi trust is a fictional concept. It is a temporary testamentary trust first created during the reign of Henry VIII of England through the CESTUIK vi Act of 1540 and updated by Charles II through the CQV Act of 1666, wherein an estate may be effected for the benefit of a person presumed lost or abandoned at sea, and therefore assumed dead after 7 years. Additional presumptions by which such a trust may be formed were added in later statutes to include bankrupts, minors, incompetents, mortgages, and private companies. The original purpose of a CQV trust was to form a temporary estate for the benefit of another because some event, state of affairs, or condition prevented them from claiming their status as living, competent, and present before a competent authority. Therefore, any claims, history, statutes, or arguments that deviate in terms of the origin and function of a CQV trust, as pronounced by these canons, is false and automatically null and void. A beneficiary under a state may be either a beneficiary or a CQV trust. When a beneficiary loses direct benefit of any property of the higher estate placed in a CQV trust on his behalf, he do not own the CQV trust. He is only the beneficiary of what the trustees of the CQV trust choose to provide. As all CQV trusts are created on presumption, based upon original purpose and function, such a trust cannot be created if these presumptions can be proven not to exist. Since 1933, when a child is born in a state under inferior Roman law 3 CESTUIK vi trusts are created upon certain presumptions specifically designed to deny forever the child any rights of real property, any rights to be free, and any rights to be known as man or woman, rather than a creature or animal, by claiming and possessing their soul or spirit. Pope Boniface III, the executors or administrators of the higher estate, willingly and knowingly convey the beneficial entitlements of the child, as beneficiary, into the first CESTUIK vi trust in the form of a registry number by registering the name, thereby also creating the corporate person and denying the child any rights to real property, and claim the baby as chattel to the estate. The slave baby contract is then created by honoring the ancient tradition of either having the ink impression of the baby's feet onto the live birth record, or a drop of its blood, as well as tricking the parents to signing the baby away through the deceitful legal meanings on the live birth record, which is a promissory note converted into a slave bond, sold to the private reserve bank of the estate, and then conveyed into a second and separate CQV trust per child, owned by the bank. When the promissory note reaches maturity and the bank is unable to seize the Slave child. A maritime lien is lawfully issued to salvage the lost property and is monetized as currency issued in series against the CQV trust. Claim the child's soul via the baptismal certificate. Since 1540 and the creation of the first CQV Act, deriving its power from the papal bull of Roman cult leader Pope Paul III, 1540, when a child is baptized and a baptismal certificate is issued, the parents have gifted, granted, and conveyed the soul of the baby to a third CQV trust owned by Roman cult, which has held this valuable property in its vaults ever since. Since 1815, this third crown of the Roman cult and third CQV trust representing ecclesiastical property has been managed by the bar as the reconstituted gala, responsible, as grim reapers, for reaping the souls. Each Sestui Kvi trust, created since 1933, represents one of the three crowns, representing the three claims of property of the Roman cult: real property, on earth, personal property, body, and ecclesiastical property, soul. Each corresponds exactly to the three forms of law available to the gala of the bar courts: corporate commercial law judges the landlord, maritime and canon law judges the banker, and Talmudic law judges the priest. Papal bull in Roman Catholicism, an official papal letter or document. The name is derived from the lead seal, bullet, traditionally affixed to such documents. All legitimate papal bulls were issued on human skin, usually the skin of a sacrificed child or some famous heretic. Express Trust Deeds Anam Sanctam 1302. The Anam Sanctum is an express trust deed. The last line reads, "Furthermore, we declare, we proclaim, we define that it is absolutely necessary for salvation that every human creature be subject to the Roman Pontiff." It is not only the first trust deed in history but also the largest trust ever conceived, as it claims the whole planet and everything on it conveyed in trust. Pope Boniface VIII believed that all authority is derived from God, and that the Pope, as the vicar or lieutenant of Christ, was the highest embodiment of his will on earth. This papal bull effectively made the Vatican the caretaker of souls to assure salvation. Triple Crown of Baal, aka the Papal Tiara and Triregnum Ball. Etymology: late 14c, biblical, from late Latin ball, Greek ball, from Hebrew baal, literally owner, master, lord, a title applied to any deity. ROMMUSPONTIFEX 1455. The first crown. Land real estate. Pope Boniface VIII was the first leader in history to create the concept of a trust, but the first testamentary trust through a deed and will creating a deceased estate was created by Pope Nicholas V in 1455 through the papal bull Romanus Pontifex. This bull had the effect of conveying the right of use of the land as real property from the express trust Anam Sanctam to the control of the pontiff and his successors in perpetuity. Hence, all land is claimed as crown land. This first crown is represented by the first Sestui Kvi trust, created when a child is born. It deprives us of all beneficial entitlements and rights on the land. Aeterni Regis 14812 ND Crown Commonwealth Personal Property. The second crown was created in 1481 with a papal bull Aeterni Regis, meaning eternal crown, by Sixtus IV, being only the second of three papal bulls as deeds of testamentary trusts. This papal bull created the crown of Aragon, later known as the crown of Spain, and is the highest sovereign and highest steward of all Roman slaves subject to the rule of the Roman pontiff. Spain lost the crown in 1604 when it was granted to King James I of England by Pope Paul V after the successful passage of the Union of Crowns, or Commonwealth, in 1605 after the false flag operation of the Gunpowder Plot. The crown was finally lost by England in 1975, when it was returned to Spain and King Carlos I, where it remains to this day. This second crown is represented by the second Sestuikevi trust, created when a child is born in, by the sale of the birth certificate as a bond to the private central bank of the nation, depriving us of ownership of our flesh and condemning us to perpetual servitude as a Roman person or slave. Convocation 15313 Road Crown of the Ecclesiastical See Soul Baptism. The third crown was created in 1537 by Paul III through the papal bull Convocation, also meant to open the Council of Trent. It is the third and final testamentary deed and will of a testamentary trust set up for the claiming of all lost souls lost to the sea. The Venetians assisted in the creation of the first Sestuikevi Act of 1540, to use this papal bull as the basis of ecclesiastical authority of Henry VIII. This crown was secretly granted to England in the collection and reaping of lost souls. The crown was lost in 1816, due to the deliberate bankruptcy of England, and granted to the Temple Bar, which became known as the Crown Bar, or simply the Crown. The bar associations have since been responsible for administering the reaping of the souls of the lost and damned, including the registration and collection of baptismal certificates representing the souls collected by the Vatican and stored in its vaults. This third crown is represented by the third Sestuikevi trust, created when a child is baptized. It is the parent's grant of the baptismal certificate title to the soul to the church or registrar. Thus, without legal title over one's own soul, we will be denied legal standing and will be treated as things cargo without souls, upon which the bar is now legally able to enforce maritime law.